Alrighty, check, radio check. A couple things. For those of you that were on last week, you know that I got a little choked up because my uncle had passed away, and I actually left Friday morning, was able to fly down to Virginia and pay my respects, and I was able to fly home Saturday because the celebration of life is not going to be for another 2 weeks, and I will be out of town. But it was bittersweet to see family and share stories. I was able to ask a lot of questions of my past. I saw pictures of my uncle in his youth, of my dad, my grandmother, my other uncles' families. It was important to be able to connect a lot of those dots. But I wanted to thank all of you for at least allowing me to partially pay a tribute to him. He will be missed. He's a great man. He was one of my pillars of strength. And with that, all I can do is continue to convey the message, which is hug the ones you're with. And, as we go through this journey we call life, we're faced with challenges. We're faced with things that are unexpected. And all we can do is just live the best life that we can today. So without further ado, I'm going to take us through the topic today. Because there's so much content here, I'm going to break this down into 4 different segments. And the other thing I want to just make sure that everybody knows that when I'm speaking about wills and trusts and estate planning, as a financial planner, as a fiduciary, one of the things I want to make sure that everybody knows, I am not an attorney. I am not giving legal advice. What I am doing is trying to take complicated subject matter or things that can get confusing and help to simplify them. So without further ado, today, our topics, the series topics, will be estate planning basics. That's what we're going to cover today. Probates and trust, we'll touch base on that. And then we'll get into the Secure Act in your estate and estate plan comparison, and then the impact of customized estate plan. Now, whether I break this down over 4 weeks or I am able to condense a couple of the chapters, I will. But for today, right, without proper estate planning, not only do you lose control over important decisions, but the administration of your estate can become complicated and expensive, right? This is part of where some of the tools that we've had, whether you go to an estate planning attorney or whether you use one of the programs that we utilize, and then last week was on liquidity planning. All these things sort of are intertwined. But estate planning basics, so what we're going to talk about today is what is an estate? And you go, oh, it's so simple. I know, right? What is estate planning? Do you need an estate plan? And then how do assets actually transfer upon death, right? So what is an estate? And this is from Oxford Dictionary. All the money and property by a particular person, especially at death. So basically the way, I guess the US law works is they're going to view all your assets. And when I say all, I deal with folks from different countries. They have houses over there. They, don't tell the IRS about this. At the end of the day, the IRS wants, in New Jersey, wants their pound of flesh, right? When we're transferring assets from one generation to a next, from ourselves to our loved ones, right? There's a couple different ways that can happen, but it's an aggregate amount of money or assets that are cumulative, and then how do they transfer? I found this and I thought this was good because most of our clients that we work with are in New Jersey. Now, everything is subject to state law, right? So you have federal taxation laws, but when it boils down to the transfer of assets, that boils down to a state level. So what happens if a person dies without a will or trust in New Jersey? And that's a fair question. When no will or trust exists, things get much more complex. A person's real personal property is not distributed according to a person's verbal or unwritten intentions, if known. Rather, it is distributed according to the laws of the state of New Jersey. That is why estate planning with a will or trust is so important. If a person dies with assets but with no will or trust, an administrator for his or her estate must be appointed by the court. So I am going to sort of ask a question here. It's a rhetorical question. Do you have a will? Do you have a trust? I can tell you that 9 out of 10 folks that I meet with do not. Or if they do, I see the date, because that's the next question. When was it done or reviewed last? And typically they're in excess of 10, and I've seen many as 20 years. So when I see that, I will put the paper down and I go, look, whether we do business or not, I just want to ask you a question. Name one thing that New Jersey manages well. And I shut up. And usually the response I get is crickets. It's very hard or difficult to point to anything that New Jersey actually oversees and says they do a very, very good job. They're very efficient. They're very fair. So if that's the case with most things, right, that our state government oversees, how could you, as a citizen of this state, expect anything to be different should you pass without instructions? Because what you're basically saying to the state at that point in time is, here you go, New Jersey, you figure it out for my family. And that can tend to be inefficient and expensive. So what is estate planning? Estate planning is a process of anticipating and arranging during a person's life for the management and disposal of the person's estate during the person's life, in the event the person becomes incapacitated and after death. So there's some key words in there. Incapacitated. You know, a lot of us don't think that anything will happen to us. You know, we just, I mean, we're human beings, and it's very difficult psychologically to view ourselves and our demise. Now, we can view our spouses or significant others or family members, we can envision that, but human beings typically have a hard time looking at themselves and envisioning some type of tragedy. Now, I'm not talking a little bit of worry, or I'm talking about, hey, listen, like I said, some of you may know, one of my best friends at a very early age, when I went into the Navy, was hit by a drunk driver, and he has spent the rest of his life as a quadriplegic in a wheelchair. So I've seen firsthand how a disability works. I also had a client that called me last week, 2 weeks ago. Her husband, I mean, she's 62 and I think he's 63. They're trying to bridge this gap to 65 to get Social Security, to get access to Medicare, Medicaid, because he has had a deterioration of health and mental capacities, now out on permanent disability. So he has been picked up through Social Security, and some of his company's corporate plan, long-term disabilities, is covering some stuff. But that word incapacitated, I did not want to gloss over. Right? We can all envision, hey, somebody dies, it's tragic, and we talk about it. And like I said, I just experienced it last week with my uncle. But it's what happens if we're alive? How do things work, right? So that's where estate planning can be beneficial. So do you need an estate plan? Now that we've defined what an estate is and what an estate planning covers, how do you know if you need an estate plan? Many people think that just because they don't have many assets, they don't need a plan. Well, let's look at an example. Right? So this is Sean and Mary Williams. I'm not going to read you everything that they got on here, but they got some assets. They're not overly wealthy, right? But they're 58. That's the key thing I wanted you to see here. We weren't talking 65, 70, 75, although those people are much further down the road and probably do need some attention to their affairs. This just happened to one of my advisors last year at 57. He's in South Carolina working on the farm, and turns around and a tree falls on him and he passed. Now, he had more assets than this, but I point this out because he had 2 kids. But let's look at this hypothetical example. 2 are upstanding children, but the third had some bad spending habits. Not uncommon, right? Kids today, they think money grows on trees. They don't know, they haven't experienced the world. So they had a home worth $250. He had another piece of property. He goes hunting on $75,000, right? Joint accounts. Now, when we're, married couple, right, we can typically get our hands on things, but depending on how those accounts are titled, right? I know for me personally, I have joint accounts with my wife, but I also have my own separate accounts. Then you got IRAs, qualified plans, and you see that word beneficiaries next to it. This is important, and I've shared this before, but had I not seen it firsthand, I wouldn't have probably started to stress this as much. I had a client of mine come into my office. He had been married for about 5, 6 years, and we were following up on an insurance contract that he had. I know what it was, his old 401k, and we were moving that. And part of their challenge question was, who is the beneficiary of this account? And when he named his current wife, they said that's incorrect. So then his natural next response was his previous wife. His ex-wife was still named on the beneficiary. Now, his current wife was not in the room at the time, but the look on his face is etched in my mind forever. And obviously we got that corrected and fixed, but this is why reviewing beneficiaries is really, really important. We get busy, time passes, things change, right? We get married. Unfortunately, some people get divorced, right? People pass away, they get remarried. All of these things happen. Got to check your beneficiaries. Bank accounts, like I said, some are in one person's name, some are in the other person's name. Joint bank accounts, and then you see here IUL policy. Now, I talked about last week the BLP, right? The liquidity plan. And I think that's something that all of you, if you've not seen it, heard of it, or listened to it, I am now preaching that from the rooftops. And it's only because I've gone through it firsthand. And I was just on a call this week with my partners, and I heard my other partner in Minnesota has 3 estates where the insurance companies have taken 6 to 8 months to process a death benefit. And the reason being is because they can't get a definitive cause of death from the medical examiner. Most ways that you transfer or pass assets need a death certificate. And today with just the environment, it's becoming harder and harder to get. Once you got it, it should be smooth. And I mentioned last week in New Jersey right now, unless you decided you want to go to downtown Trenton, it's 6 to 8 weeks right now processing time. So here's the example in the hypothetical. An emergency. Sean's been rushed to the hospital after suffering a stroke, right? After his morning run. Incapacitated. He didn't die, but now probably can't work. So who has control over his medical decisions? Well, that's where a healthcare power of attorney authorizes an agent to make medical decisions or consent to medical treatment on your behalf. Or a living will. It's an advanced healthcare directive, provides your instructions for how you want to be treated in end-stage medical condition or permanent vegetative state. Think Terri Schiavo and the Terri Schiavo cases from way back when. So, if these things are not in writing, local medical facilities are under state law to keep you alive and to try and to maintain life support, where that might be the furthest thing from your desires. And it can be very expensive if some of those procedures are not covered. All right, so who has control over Sean's financial affairs? You would think naturally his wife, right? Durable financial power of attorney authorizes an agent to manage your financial affairs if you become incapable of managing them yourself. But that has to be done prior to. So that's where that, I always explain that a power of attorney or durable power of attorney, right? So that's the key word there. It's like a pen, right? This pen here, I hand it to my wife. She can now act on my behalf. But the benefit of that is if for whatever reason I want to take that pen back, I can absolutely do so. But that's only while I'm alive. If I pass, that pen disappears and it's now whatever's the process or the instructions in the will. So you see there, springing power of attorney requires medical determination of incapacity. So you need a medical doctor to basically say, hey, listen, this person's incapacitated. And now this springing power, that's where it comes into effect because they've been deemed incapable of doing it themselves. And then it's immediately effective when signed, right? So it avoids these guardianship type proceedings, very lengthy processes. Now, unfortunately, let's say Sean passed. Sean has passed, leaving behind his wife and 3 children. And that's the example I just mentioned with the advisor, 57 years old down in South Carolina with 2 children, right? So in general, dying without your own estate plan means that your family gets subjected to your state's law of intestacy, the government's way of deciding how your assets get divided and distributed upon your death. Bottom line is the government decides how things get divvied up. So if Sean had had a will, in the will, he could have provided instructions, right? For the distribution of his estate upon his death and appoint a person, an executor, a successor trustee, it's also known as an executrix or a personal representative to administer his estate. Now, if somebody's going to do that, you need to let them know that you're going to name them, because I've been an executor on an estate. It is a burden, right? One of my clients way back when, he asked me to do it because he was remarried. He didn't trust her kids, and his two kids, one of them was he had challenges with, and he wanted me to oversee that stuff to make sure. Now they both since passed. I actually just spoke to the one daughter yesterday, and so watching this full circle assets pass through generations, that's what I do. I help people to accomplish their goals, but having these instructions in place are absolutely critically important. So then, advantages of a will. Well, you select a personal representative to carry out your final wishes. You decide to whom your estate gets distributed to and how and when it gets distributed. You select a guardian for minor children. Normally it's less expensive than to set up a will-based plan, right? So this is the least expensive way to do it. Disadvantages though, your will is subject to probate. What the heck does that mean? We hear about it all the time, but what's it really mean? It really means everybody under the sun has access to your personal information. If you don't want that, you need a trust. But if you just have a will, they get to go on down to the courthouse, and when all this stuff is all settled, everybody will know what you had, what you owed, who you wanted it to go to, and they can follow the money. So your will can be challenged. Your assets can and will be subject to your creditor's claims, right? So if there's somebody owed money and it was just in the will, somebody's going to, put a lien or a suit against the estate. Your will is public, and all the information about your assets are available to the public. That's the number one reason why people typically will do trusts. I'm not saying, so, hey, if they're in a life insurance policy, if they're in a IRA, 401k, something like that, those assets pass just by the beneficiary form. So we don't have to worry about it so much, but it's all the other stuff, the house, the money, the cars, that's the executor's job, is to get their arms around the assets, put it all into an account, and then distribute it. All that becomes public knowledge. Your assets will not be made available to your heirs until your estate is approved by the court. That's the key one. Like I told you, the one in South Carolina, it just boggles my mind that they had, an estate in excess of $2 million, and she couldn't get her hands on a lot of that money because they did not have a death certificate. How do assets pass when you die? So this is where a lot of people think that I'm going to go down, I'm going to do this. Jointly held assets. So again, husband and wife jointly held, as long as two signatures were not required on that transaction, then yes, that person would have access to some funds. But how much money do people typically hold in a joint account? The beneficiary designated assets. That's what I was talking about, that will pass directly for wherever the clearinghouse is, TD Ameritrade, Fidelity, Vanguard, your 401k. If they have beneficiary designation slots, they're going to go directly to whoever was named. But review those to make sure that who was listed is either still alive or who you still want to be. Then ultimately transfer on death, the TODs, or the payable on death. This is the one where a lot of people will set up accounts and they think, okay, well, that'll transfer on death, but you need a death certificate for that to get all of these things right here. This is the thing that I think that's why I was so impressed with the beneficiary liquidity plan. You don't need a death certificate. We can take care of the initial funeral home expenses, even with the funeral expense plan, typically that are quite often touted. You still need a death certificate. And if you can't get one in a reasonable amount of time, then you're borrowing money from somebody, a family member, or maybe even the funeral home at above average interest rates. So my point is that when you're thinking about what do you want to have happen if we're not here or we're incapacitated, having a plan. Nobody wants to talk about it. It's uncomfortable. Nobody likes to think about it because it does bring up negative feelings. But this stuff is important because the alternative is you get to deal with the state in which you reside. And do we trust them more than the people that are in our lives? Just that's my last slide for this week. I just make sure, again, no call next week. When we get back, it will probably be a market update. And then from there, we will continue on this topic and keep, some other things to start to think about how trusts work and the Secure Act. So these are disclosures, just talk about that, everything that I showed you here, is been reviewed. And then if you have questions, this is the biggest thing is that, look, folks, this stuff is complex. I don't know everything about everything, but I've been doing this for a while. And if I don't know, I do know attorneys. I do know people that do know the answers, and I'll typically try and give you and guide you in the right direction. So without further ado, I want to thank you for taking time out of your week, being on my call. Have a great day, stay safe, and talk to you soon. Bye-bye.